Hi folks, Lee Pacchia here, and you're watching Between the Lines, part of Fault Line's effort to take a look at the cracks in America's criminal justice system. We finally got Andrew Fleischman on the program. I'm happy to say he joins us today from his office. Andrew, good to see you. Welcome.
It's a pleasure to be here.
So you had a really interesting article that dropped on Fault Lines today. I'm going to read the title here. Is a racist juror reason for reversal? SCOTUS takes the case. This begs a lot of interesting questions that we're going to get to today. My first is, Andrew, can jurors be racist?
Yeah, legally, juries can be racist for the most part. Well, the question isn't really so much about whether juries can be racist, but how are you allowed to discover it? So, for instance, if somebody overheard a juror in the hallway saying something very racist, you could probably bring that witness in. The rule we're talking about is just Rule 606, which says when can you bring a juror in to testify about something that happened in the jury room. And for the most part, it's limited to just a few circumstances. Typically, if there's an outside bribe, if somebody starts researching stuff on the internet, or if somebody just checks the wrong box. They meant to fill in not guilty, but they filled in guilty by mistake. So what this case deals with is not so much that it's not a problem if jurors are racist, but what are the appropriate ways of figuring that out? And here it seems like it's pretty limited.
Well, let's do the backstory here. What exactly is the case that got all the way to the Supreme Court? Walk us through it.
So this is this guy, Pina Rodriguez. He works at a racetrack. These two girls allege that they're in this room. Some guy asks them if they want to party. He turns off the light and gropes them. They swat the hand away. They go run to their dad. And when they describe the guy to their dad, he says, "Oh, that sounds like this Rodriguez guy who also works at the racetrack." So police go pick that guy up later that night, drive him over in a squad car to the girls, who identify him from 15 feet away in the dead of night through the squad car window. So not terribly strong evidence. That really was the evidence of guilt in this case, given that there was an alibi. So the guy gets convicted anyway, and it turns out two jurors linger after the verdict, and they say, "Oh man, it looks as though this guy kept saying that Mexicans simply aren't trustworthy, that they're aggressive towards women, that he's exactly the sort of guy that would do this because he's Mexican, and that's why I'm convicting." And the defense attorney tries to bring that up at the motion for new trial to persuade the judge that there was a due process problem. But because of Rule 606, which exists in Colorado and across the country, he couldn't do that. He couldn't bring in the affidavits of those jurors to talk about the racist comments made by the dissenting juror, HC.
So what's the reason for that? Why can't that be brought up at that point in the process? And is this something that needs to be fixed?
Actually, I think probably not. So the reason it can't be brought up is, first off, you want people to show up for jury duty, and you don't want them to dread being dragged back to court for years after a verdict's been rendered. And you want them to be able to render unpopular verdicts and feel confident in that. So we have this rule basically to prevent people from calling jurors back and try to figure out what their deliberative process was. And it does lead to some bad results. I mean, this is a classic example. We've got this super racist stuff said by this guy, and then we want to go ahead and peer into the jury room and say, hey, did they convict him just because of racism? But on the flip side, if we eliminate this rule or weaken it, and I think Judge Kopf mentioned this in the comments, you just open up a whole can of worms. It's not just defendants that want access to this information, bear in mind. For instance, so the basis for bringing this in is like the argument is that the juror's racism is like an extraneous belief he had before he entered the jury room. And so he's not really acting as a juror and he's violating his oath and we should peel that back. But think, for instance, of a juror who believed in nullification, right? So a prosecutor might try to bring that juror back in after the acquittal or, say, mistrial and say, oh, gosh, there was a problem with this. This juror snuck in and it's not a true verdict of acquittal or there's a real issue here. I mean, these rules protect defendants as much as they protect convictions. I'm not so sure we should be tampering with it.
Yeah. Still, from a public policy standpoint, I don't really love the idea of open and avowed racists sitting on juries.
No.
Like, there are problems here.
And maybe the better way to deal with it would be to, say, open up the ability for people to check people's Facebook feeds before they're put on juries. Or maybe more intensive questionnaires on people to really figure out if they have these sorts of biases. But everybody's got a bias. And I personally can't see a principled line between, say, racism as a bias or really hating the government or being strongly pro-drug or, maybe thinking that anybody who's in front of the court is guilty. Those are all biases that people have that someone finds objectionable. And I think once we open the door to one set of biases, I don't really see how we stop that. What's special about racism, in other words, that's different from other types of pretrial bias so that we can do this? I'm not sure I can put my finger on it.
Yeah, no, I see your point. So let's get back to this case. There's 8 justices on the Supreme Court now with the passing of Justice Scalia and our apparent inability to put a replacement on the bench, at least in the foreseeable future. How do you see this case going down?
I see the petitioner winning, actually. Not just because of that awesome 68% figure that 538 provides, that petitioners win 68% of the time when cert is granted, but also because basically Worker 2 years ago said that you can't bring stuff up just because it might be extrinsic. That dealt with a woman whose daughter killed someone in a car accident, and she refused to award damages to the plaintiff in a car accident case because she was worried about what would have happened to her own daughter. And what the court said in that case is, unless there's some sort of extreme bias, we certainly wouldn't even consider allowing you to do that. Then this case comes along and suddenly they grant cert. Just reading the tea leaves and given that she's the petitioner, I see the petitioner winning here. Also, the court chose a case with such weak evidence against the defendant. I can't think that was accidental.
Andrew, great article today. It's making the rounds, and I'm sure you're going to have a follow-up for us at some point in the proceedings. When this goes to argument, what are some of the things you're going to be looking for?
I'll be curious to see what Alito says. He actually, on the Third Circuit Court of Appeals, had a really interesting opinion on this topic. I think even Alito, as pro-government as he is going to end up saying that we do have to draw a line somewhere, and racism might be that line. I think the court's going to have a difficult time taking the extremely unpopular stance that racist jurors should be allowed to convict people for racial reasons.
Sure. Andrew, again, great article. For those of you, keeping track at home, the title of it is a Racist Juror Reason for Reversal? SCOTUS Takes the Case. As always, you can find it under the Fault Lines tab at MimesisLaw.com. Andrew Fleischman, thank you for your time today, sir.
Thanks.
That's what we have for this week. Again, if you're interested in the stuff we're working on, be sure to go check us out at Line. You can find us at MimesisLaw.com under the Fault Lines tab. We're also on Twitter, Facebook, LinkedIn. We're all over the place. If you're listening to us as a podcast, do us a favor in iTunes and write us a good review. It makes all the difference in the world. If you're watching us on YouTube, do us a favor and subscribe to this channel. There's more good stuff coming. I can promise you that. I'm Pacchia. Thanks for watching. See you next time. Mr. Buck is not necessarily the most ignorant of people when it comes to what's happening out there. He's a former prosecutor.
Yeah, he's a former prosecutor who's very, very solidly in this mindset of, if I believe something's right, I'm going to pursue it, no matter what. Before we actually got on the line today,